Good evening, all, and welcome to this 2-hour CP virtual program of the SIRC of ICAI on yet another new topic, arbitration opportunities for profession. I take the pleasure of inviting the guests and the delegates for the day. Today, in the absence of our chairman, Mr. K. Jalpati, who has chosen this topic, we have been what's called in the forefront to cover the maximum areas of professional opportunities through newer areas of practice. So this is one such area, and we have with us one of the erudite personalities and very experienced personalities in this field, Mr. V. Inbavijayan, international arbitrator, to speak on arbitration, the professional opportunities or the opportunities for the professionals. So on this, he has been here. Sir, thank you very much for accepting our invitation, and a very hearty welcome to you for this webinar, sir. I also take the pleasure of inviting our regional council member and also treasurer of SIRC of ICAI, Mrs. Revati Raghunathan. Welcome, madam. Revati Raghunathan, madam. And also, I very heartily welcome you all, that is delegates. We have taken interest in this, and nearly 200 members have registered for this. And on this Yugadi day, which is a big festival for some places, and tomorrow I think it is Tamil New Year, and here it is a big festival for Karnataka and Andhra people. And I, sitting at secretary of SIRC, sitting at Bellary of Karnataka, we did celebrate Yugadi. Still it is on. So I wish you all a happy Yugadi and various other festivals by whatever name called for the day. So with these greetings, I welcome you all once again, and request Revati Raghunathan madam to formally introduce the speaker and before he takes off the technical session. Over to Revati madam.
Yeah. Good evening, sir. Good evening, Panara sir, and good evening, Inbavijayan sir, international arbitrator. A very happy festivities for everyone under the different nomenclatures in which we are celebrating the new year. We have a very new, I would say, an old profession in a new garb, because I think it is taking off in a very big way now, this arbitration. In fact, most of the since the judiciary is overloaded and there are so many compliances which need to be done, these alternate dispute resolution methods are once again coming to the forefront to ease the burden on the judiciary and enable the businesses to reach some kind of a dispute resolution which is not very long drawn out, but within a time bound manner, like the negotiation, conciliation, mediation and arbitration. And I'm sure that most of my professional colleagues here will know that institute is also conducting an ADR certification course, wherein we do this conciliation, arbitration and other forms of dispute resolution. And this is we are taken through this by a number of advocates who are in practice in this area. And I was just talking to our speaker some time back, and he was telling us that a regulation is going to be introduced to regulate this profession, and certifications such as this, even though it may not be mandatory, will definitely be helpful to us in getting more opportunities in a newer area where it is more of opening up the practice of arbitration. So going straight away to the introduction of the speaker, I went through his profile, and it is an amazing profile. He is a BA, BL, FICA, IADR, FPI Arbitration, PAP, KFCRI, FCI, ARB, UK. He is an advocate, international arbitrator and mediator. Sir, those are the only things which I understood out of the various alphabets which followed your name. He is a managing partner of COVI Global LLP. He's the Global Examinations Board member of the Chartered Institute of Arbitrators UK. He is a regional pathway leader and post director and fully approved tutor of CIARB UK. He is a co-chairperson, Chartered Institute of Arbitrators, South India chapter, Vice Chairman, Society of Construction Law India, Chairman, SIRC Arbitration Committee India, Advisor and Post Director, Bangladesh International Mediation Society, Bangladesh, Visiting Professor, Tamil Nadu Dr. Ambedkar Law University and Indian Maritime University, Global Advisory Board Member, Hyderabad Arbitration Center, India, Managing Committee and Global Advisor, Covis Foundation, Conflict Resolution International, Technical Assistance and Advisor for various ADR institutions worldwide. He is, those are his qualifications. A little more about him. He was educated at the Dr. Ambedkar Government Law College. On completion of his education, he took up litigation practice at High Court of Madras in 1997. And his enthusiasm towards ADR made him pursue it as a whole-time practice since 2001. So far, he has presided as sole arbitrator and represented as counsel in over 350 domestic cases, several thousands of small claims, commercial, financial arbitrations, and 15 international arbitrations. His areas of practice include international commercial arbitration, maritime arbitration, international trade and contracts, IPR, construction disputes, finance and banking disputes, securities markets, JVs, LCs, alternate dispute resolution, sale of goods, domain name disputes, and investment disputes. He is an accredited arbitrator, and there is so much more which I can talk about him. He is a regional pathway leader for domestic and international arbitration, construction arbitration, mediation courses, and he finds mention in the Chambers Asia Dictionary, which is the international who's who of commercial arbitrators, where he's mentioned in 2010, 2011, and 2012 as Veeraraghavan Inbavijayan earns accolades for his noteworthy knowledge in arbitration. He undertakes both domestic and international arbitration, particularly in international trade and commercial disputes. This is his latest description in the who's who. He's referred many more times in the who's who of the commercial arbitrators. So, friends, I present to you one of the leading international arbitrators. I think we are fortunate enough to have him as a faculty for us to guide us through the opportunities in arbitration. Over to you, sir. Thank you very much.
Thank you. Good evening. First of all, thanks for the opportunity given by CA Institute, and more specifically the chairman, Mr. Jarapati, Mr. Pannaraj, the secretary, and Mrs. Revati Raghunathan, the treasurer. It is always a privilege to address non-legal persons and non-legal professionals, most interestingly. Whenever I am going to address before chartered accountants, the most common word the lawyer use, and colloquially we address chartered accountants as auditors, is quite afraid. Whatever the information we are going to give, it has to be true, specifically true, as well as it has to be authenticated. So much of information has to be given before a chartered accountant being the audience. And being a lawyer, it is quite hard to always talk about truth. Okay, with this formal words, I like to go into the technical part of my presentation for another more than around 90-95 minutes. Arbitration, as rightly introduced by the secretary as well as the treasurer, you have a course. A certificate course of ADR is being provided by the Chartered Accountants Institute. Why? It is only exclusively done by the CA Institute. Even when we go to the Bar Council, which is a regulator for the lawyers, we don't have a course for or a certificate course for ADR or arbitration or mediation. Even if you go for the Company Secretary Institute, we don't have. But very interestingly, CA Institute alone has the certificate course, not started recently. It was last a decade, more than a decade the course was there, but it was in a different name. Certificate course on arbitration, mediation, and conciliation. Then now we have the certificate course on ADR. There's very significance of having this course for the chartered accountants is that you are all eligible to sit as arbitrator. That is the prime objective of that particular course. The opportunity what you have as chartered accountants is to arbitrate. To arbitrate in the sense, it is quite a role which is technically called an judge, a private judge. A private judge nominated by two parties or the disputing parties having fullest trust on that particular person to decide its own disputes. This is the opportunity what we have when we opt for arbitration, particularly the core certificate course on ADR or arbitration and mediation. Having said that, why we are all going to arbitration and to what extent we have this opportunity to arbitrate or take up any other role in this arbitration process. Now I'll try to share a PPT so that it will be really interesting to all of you. Okay. Yeah. This is a formal introductory slide what you all are going to further run through to the entire session. The first thing you have to keep in mind that we have to avoid taking our litigation to courts. We have to only take the path of arbitration. That is the main objective what we should have. As rightly pointed out by the office bearers of SIRC is that there is a huge backlog of cases in the courts. And if it is going to be a huge backlog, the entire system is going to collapse. We can't expect the judiciary to deliver the justice of any case, whether it's a commercial case or it's a technical dispute or it's a personal dispute or it is regarding a financial dispute or any commercial disputes. It takes its own time. In an average, if you can see, a case is being taken to the court of first instance. There is a trial court, which initially the cases are being filed. In that particular court itself, in an average of 4 to 5 years, we have to just deal with the case and ultimately we are going to get a judgment or a decree. It doesn't end there. We have an option for appeals. The appeal ultimately goes to district courts, then it goes to High Court, and finally to the Supreme Court. There's various layers of appeals, which is all the rights of the parties. No doubt it is a right, it has to be exercised. It all leads up to a long delay in this process, and ultimately the judicial system is going to be burdened with heavy backlog of cases. This is one part of the ill effect of the litigations in the courts. The other part is the cost. The parties are going to, or the litigants are going to spend not only the court of first instance, the appeal courts, and ultimately the Supreme Court. They are going to spend a lot of money. And very interestingly, a litigant cannot have a predetermination of the value or cost what is going to incur in this particular litigation process. Further, when we take up a dispute to courts, obviously the time taken, the cost, as well as the procedure. The procedure complexity, what we face in the courts, particularly when we are going to apply the Civil Procedure Code or the Indian Evidence Act, which is considered to be the two epics of our judicial system. These two legislation leads to lot of delay, lot of complexity in the procedures of the process, and ultimately most of the cases get unresolved, and in some occasion the matters might be resolved amicably. This complexity in the procedure, which we can't evade, is ultimately making the judicial system stressed a lot. If you are going to have a system which is going to be delayed, a system which is going to be without predetermination of cost, and the system which is going to have complex procedure, then it is always better to find an alternative. An alternative is considered to be all these arbitration, mediation, conciliation. And when we are practicing as a lawyer, and another concept is called lok adalat. All these are very common alternate dispute resolution, which is being suggested as an alternative to the judicial system. Having said that, very commonly we come across the acronym ADR, and we call it as alternative dispute resolution. But we can also say this as an authenticated dispute resolution, accepted dispute resolution, as well as authorized dispute resolution. Accepted, authorized, as well as authenticated dispute resolution. All these goes along with alternative dispute resolution. So much of significance is given to this ADR system. This ADR system, of late, very recently, after the 2010 legislations, the changes in various legislations, particularly commercial legislations, we have a lot of opportunity to take our disputes to ADR. A good example is the Companies Act. Many would be familiar with the Companies Act, the 1956, and the recent repeal, and we have the new Companies Act 2013. In the new Companies Act 2013, a mediation concept is being included. When you have time, you can just look into section 448, runs through the various subsections. It deals about mediation and conciliation. Then we have the Commercial Courts Act 2015. That Commercial Courts Act facilitates pre-litigation mediation, and not only that, it is now being facilitated as a mandatory pre-litigation mediation. Thirdly, in 2019, we had the change in the Consumer Protection Act. The original Consumer Protection Act, which was enacted in the year 1986, got amended in 2019. And in 2019, an exclusive mediation process has been recommended in that particular regulation. And now consumer disputes can also be mediated, not arbitrated. At least we can mediate. All these changes, in addition to various judgments and the judicial observations, like the judiciary gave an observation about why we need to have only rules and regulations for mediations. We can better have a law, a mediation law. That was the observation given by former Supreme Court Judge Justice Sikri. And subsequently, a creation of an authority called MAMA, that is Motor Accident Mediation Authority. This is giving opportunity for motor accident claims to be referred to mediation. And most interesting and the pioneer of promotion of ADR is the Babri Masjid dispute. The Supreme Court constituted a mediation panel, and that mediation panel recommended, and based on that recommendation, obviously the historical disputes got resolved. All these were great development happening in the judiciary, along with another interesting development in 2002, which was an amendment in the Civil Procedure Code of inclusion of section 89. That particular provision facilitated the courts dealing with pending suit. If the court finds some element of settlement in that particular dispute, the court can refer to mediation, to conciliation, to lok adalat, and even arbitration. All these added up, section 89 CPC, the Commercial Courts Act 2015, the Consumer Protection Act 2019, the Amended Act 2019, the Companies Act 2013, along with that, the various observation of Supreme Court and recommendations of the Supreme Court, with all now is being facilitated to make the parties, the disputants, to go to ADR. Simultaneously, we had this 1996 Arbitration and Conciliation Act. The Arbitration and Conciliation Act, which was a pioneer legislation in our country dealing with arbitration, was created based on the United Nations model law. It is not our own creature, it is a model law If it is going to be model law, it is a system of harmonization of the legislation. That means an arbitration act, we have an arbitration act in India. This same or similar arbitration legislation will also be there in various other countries, wherein if the countries have adopted that model law. As of now, more than 100 countries, developing as well as third world countries, have adopted this particular model law, and it is very clear that if you are going to arbitrate, not only in India and in any other countries which are model law countries, then the legislation is similar. We have a same law for arbitration. This is the opportunity what we have straight away. If you are going to get into arbitration, it is that we are not only going to deal with domestic disputes, we are also going to deal with cross-border disputes, international disputes, transnational disputes. Our opportunity is wide open. And when we are going to arbitrate, one thing you all have to keep in mind that anyone can be an arbitrator. That is the pioneer legislation, Arbitration Act 1996, particularly under Section 11. Anyone of any nationality can be an arbitrator. The same provision is adopted in all the model law countries, and it is our greatest opportunity. If you want to arbitrate, if you are going to be appointed by the parties as an arbitrator in Singapore, very well, you can arbitrate. There is no restriction. You need not get a license. There is no compulsion to get a license. Whether you are a chartered accountant or whether you are a lawyer or whether you are a company secretary, whether you are a cost accountant, that doesn't matter. You can arbitrate. You have no restrictions. That is the advantage of arbitration. Not only that, you can also represent the parties in arbitration in any jurisdiction outside our country. That opportunity has to be reasonably tapped. That is the avenues what we have at this point of time. No doubt, this legislation is not going to be relooked in any other jurisdiction in the immediate past. Having given a basic opportunity platform for all of us in arbitration, certain things we have to understand. Why we are going to arbitrate. Resolving disputes is essentially a skill. The former might be a character of a person, whereas the latter is a situation in which the characteristic is put to practice. As I just mentioned, now the courts are burdened. The problems in dispute resolutions are become complex. And when the dispute is highly technical, it is going to be even more complex. All these has to be removed. The focus has to be well clear that it is an opportunity for expert to address the dispute. We can't just expect. One another interesting thing when we are taking the disputes to courts is that the judge might be an expert. The judicial officer might be an expert in a particular area of law. We can't just expect any person to be a master in all the subject, all the technicality in the law. They will be specialized in certain area. Assuming that a dispute is of highly financial in nature, we can't just expect the judge who was a former criminal lawyer, who was very popular dealing with criminal procedure courts. At that situation, that judge would depend on an expert. That expert obviously would be a financial expert, and with the help of the financial expert, the judge would deliberate the case and finally give a conclusion, that is a judgment. That process of judging is now shared by another individual. That complexity might arise in the courts. However, we have to seriously consider if a matter is going to be referred to arbitration. In arbitration, one thing, as I just mentioned, anyone can be an arbitrator. If a dispute is of financial nature, we can appoint a person with qualification in finance as an arbitrator. If you are going to appoint that person will be the best person to understand the technicality, and he can effectively resolve the dispute. He is not going to give a judgment. He is anyway going to give an award, but he's trying to resolve that particular dispute. And arbitration is particularly a process which is wherein the disputing parties agree that one or several individuals can be appointed to make a decision about the dispute after receiving evidence as well as hearing arguments. It's a simple process. It is a process which is similar to courts, but it has a lot of flexibility when it comes to the procedure. Two things, that is the Civil Procedure Code and Indian Evidence Act is not applicable in arbitration. That is the reason why many parties opt for arbitration. And if you're going to sit as an arbitrator, no doubt you need not follow the Civil Procedure Code as well as the Indian Evidence Act. But the principles, whatever principles has been laid down in these two epic legislation can be adopted, but there is no mandatory condition for us to adopt the procedures laid down in these two epic legislation. Surely that person who's sitting as an arbitrator takes up the role of a neutral person, as well as he makes a decision on the dispute based on the evidence presented by the parties. These are some basic introduction what you have to know about arbitration. Now moving on to the types. What type of arbitration we will come across? The career opportunity is abundant. No doubt we have a lot of opportunity to arbitrate, but few disputes which are arbitrable are being highlighted here. For example, financial dispute, contractual dispute, commercial dispute, international dispute, cross-border dispute, sports disputes, life sciences disputes, disputes arising out of research and development, maritime disputes, shipping disputes, many are there. Commonly we say that sales, licensing, financial disputes, development contracts, all these are very common contracts or agreements where we entered and we end up in various disputes. But all these can be arbitrated. Here one thing, as an arbitrator or as a counsel, when you're going to get involved in an arbitration, we have to be seriously looking upon the concept of arbitrability and non-arbitrability. It is very clear that not all disputes can be arbitrated. Please keep that in mind. When you're going to sit as an arbitrator, certain disputes you cannot arbitrate even if you have that authority. Even if you have the arbitration clause, even if the arbitration agreement is valid, still certain disputes cannot be arbitrated. How to determine those disputes which cannot be arbitrated? Simple answer is that if you have or the parties have a right which he can exercise against the entire world or against an individual or an entity, that we call right in rem and right in personam. If you are going to have a right against the entire world, if you are going to exercise a right against the entire world, then a dispute which is arising out of that principle obviously cannot be arbitrated. If you are going to exercise a right in personam against another individual or an entity or an organization, that's a private right. That right can be arbitrated. That we have to be very clear. And additionally, we have a concept called if there are special legislation to deal with certain dispute. Special legislation or statute means if that legislation is considered to be both substantive and procedural, obviously that disputes has to be dealt only by that particular law and the process which has been recommended by that special statute. For example, we have income tax tribunal, we have the customs excise, now the service tax, now it's the GST tribunals. We had this intellectual property appellate tribunal, now it has been abolished. We have the family courts, we have the labor courts, we have the consumer redressal forums. All these are creature of special statutes. Those special statutes would deal with both substance as well as procedures, how to deal with the dispute as well as how to penalize the party who's breaching the norms of that particular substantive law. If a dispute is being dealt by that particular legislation, special legislation, then those disputes cannot be arbitrated. That basic knowledge has to be possessed by a person who is going to sit as an arbitrator, or a person is going to represent the parties before an arbitral tribunal. That skill is sufficient for any person to take up to arbitration. Now comes qualifications. Just now I just mentioned anyone can be an arbitrator, or any person of any nationality can be an arbitrator, but still I'm bringing a concept of a qualification of an arbitrator. Why? Because this Arbitration and Conciliation Act 1996 in the year 2019 came across a new development of inclusion of 8th schedule in that act. And now in 2021, that 8th schedule has been omitted, but this 8th schedule is going to be the future regulations or guidelines for a person to act as an arbitrator in our country. I'll just try to share that particular slide, the material. Okay, 8th schedule. Hope it's visible to all. I'll just read it. It is very, very interesting inclusion in the year 2019. Qualifications and experience of an arbitrator. A person shall not be qualified to be an arbitrator unless he is 1. An advocate within the meaning of the Advocates Act 1961, having 10 years of practice experience as an advocate. Fine. Or 2. Is a chartered accountant within the meaning of Chartered Accountants Act 1949, having 10 years of practice experience as a chartered accountant. Or 3. Is a cost accountant within the meaning of Cost and Works Accountants Act 1959, having 10 years of practice experience as a cost accountant. 4. Is a company secretary within the meaning of Companies Secretaries Act 1980, having 10 years of practice experience as a company secretary. 5. Has been an officer of the Indian Legal Services. 6. Has been an officer with law degree, having 10 years of experience in the legal matters in the government, autonomous body, PSU, or at a senior level managerial position in private sector. 7. Has been an officer with engineering degree, having 10 years of experience as an engineer in the government, autonomous body, PSU, or at a senior level managerial position in private sector, or self-employed. 8. Has been an officer having senior level experience of administration in the central government or state government, or having experience of senior level management of a PSU or a government company or a private company of repute. Or 9. Is a person in any other case having educational qualification at a degree level with 10 years of experience in scientific or technical stream in the fields of telecom, information technology, intellectual property rights, or other specialized areas in the government, autonomous body, PSU, or a senior level manager position in a private sector, as the case may be. This was an inclusion in 2019 with 9 areas wherein prescribing a qualification of an arbitrator. Fortunately, my profession also is there, which is under the Advocates Act, as well as your career also is right open. The Chartered Accountants Act 1940 is very clearly mentioned. A practicing chartered accountant obviously can be an arbitrator with 10 years experience. This was an inclusion under 8th schedule, and it doesn't end there. If you continue with this, general norms applicable to an arbitrator. This is qualification and experience, both combined together, it was included. 1. The arbitrator, this is an addition. The arbitrator shall be a person of general reputation of fairness, integrity, and capable to apply objectivity in arriving at settlement of dispute. Here comes the problem. The qualifications has been prescribed very clearly. Now, a general expectation is that that person has to be a person of reputation, having fair qualities, and a person of integrity. 2. The arbitrator must be also impartial and neutral and avoid entering into any financial business or other relationship that is likely to affect impartiality or might reasonably create an appearance of partiality or bias amongst the parties. 3. The arbitrator should not involve in any legal proceeding and avoid any potential conflict connected with any dispute to be attributed by him. The complexity increases when you look on these general norms. 4. The arbitrator should not have been convicted of an offense involving moral turpitude or economic offense. It doesn't have a lot of clarity, but it simply says should not be convicted. 5. The arbitrator shall be conversant with the Constitution of India, principles of natural justice, equity, common and customary laws, commercial laws, labor laws, law of torts, making and enforcing the arbitral award. This 5th point is was creating a great obstacle for diversified professionals and other graduates or person who are interested to be acting as an arbitrator. Conversant, the meaning of conversant is wide, and it doesn't confine only with Constitution of India. It goes on like principle of natural justice, equity principles, common and customary laws, commercial laws, labor laws, law of torts, making and enforcing of an arbitral award. This expect a background experience in law. 6. The arbitrator should possess robust understanding of the domestic as well as international legal system on arbitration and international best practice in regard thereto. This further confines the opportunity only with persons with legal knowledge or persons who are qualified to be a lawyer. 7. The arbitrator should be able to understand key elements of contractual obligations in both civil and commercial disputes and be able to apply the legal principles to a situation under the dispute and also to apply the judicial decisions on a given matter relating to arbitration. This 7th point is obviously making an arbitrator to be a judge, similar to a judge. Why? Because we are a country wherein the legal system is considered to be common legal system. And the very interesting norm of a common legal system is that in addition to codified, we don't have actual codified laws according to common legal system. We have acts, laws, but still it can be tested by the courts, and the court can strike down the legislations partially or in total. Similarly, when a court decides, the judicial precedents become the law of the land. That particular judicial decisions, that is precedents, has to be taken into consideration and it has to be applied on a given matter relating to arbitration. It is similar to a court process, in a common law jurisdiction. And when we are going to arbitrate, it is not only confined with domestic disputes, we are also going to deal with international disputes. We are going to deal with international disputes in our country. And being so, when we are expecting a common law practice, a person with a civil law background, we can't expect that person to accept the judicial decisions and deliver a award. It is quite complication. And finally, the eighth point, the arbitrator should be capable of suggesting, recommending, or writing a reasoned and enforceable arbitral award in any dispute which comes before him for adjudication. This particular terminology of inclusion of adjudication, the concept of enforceable arbitral award, makes this particular process to be confined to persons with higher exposure to legal knowledge. Predominantly a lawyer, a person with legal knowledge, a retired judge, a retired Supreme Court judge or a High Court judge or a district court judge, or a person, a senior advocate, or a person with high legal knowledge, or a person with exposed with all the common law system. All these predominantly were facilitated by 8th schedule. In addition to the qualifications, the experience of an arbitrator also has been included with certain norms. The first part, qualification, seems to be conducive. The only thing is that the 10 years we have to wait. Any professional, whether he's a lawyer or a chartered accountant or a cost accountant or a company secretary or a legal service authority or a law graduate or an engineering graduate or any graduate specialized in areas, or only after 10 years, it can curtail young practitioners to get into arbitration. With all these ill effects, I think the Arbitration and Conciliation Ordinance 2020, now it became a bill in 2021, and now we have an act specifically brought in a provision wherein now it has been removed. We can just look into the 7th point under the bill. Sorry, not the 7th point. It is 6th point, second item. To omit 8th schedule of the Act, which laid down the qualification, experience, and norms for accreditation of arbitrators. When initially we are speaking about any accreditations, any qualifications, this particular 8th schedule confines with not much of qualifications and accreditations. Now this is going to be replaced by the concept of the regulations. It is going to specify certain regulations wherein the qualifications, experience, and norms for accreditation of the arbitrator would be the future. For that, we had to wait and see. In this 2019, there was one inclusion of a body called Arbitration Council of India. Like presently, you all the chartered accountants have your institute, which has been created under the legislation, under the law 1949 Act. Likewise, the company secretaries, they have their institute. These institutes are all acting as a regulator. For an advocate, under the Advocates Act 1961, we have the Bar Council. The Bar Council acts as a regulator. Now, a new regulator is going to be created for arbitration practice. That regulator is going to be called as an Arbitration Council of India, ACI. In that ACI, we are expecting at any moment to have this particular the regulator to be created. Once that regulator has been created, two interesting things they are going to bring down along with this bringing of the regulation. One, they are going to accredit arbitrators. They are going to accredit arbitrators, and for that accreditation, the expectation is that if you have completed any accreditation course which has been facilitated or conducted by your own institute, like the certificate course of ADR already being conducted by the CA Institute. We have various institutions also running. All these certification courses which has been run by various professional bodies, those certificate courses might be a value addition for all of you to get the qualification to be accredited arbitrators of ACI. This is one role of ACI. The other role is that the ACI is going to grade arbitration institution. To the information given to me the various certificate course on ADR, wherein I was a resource person from 2011, I could find that the CA Institute also has its own ADR cell, and those ADR cells are considered to be an arbitration institution. And in future, this ADR cell also might be graded by the Arbitration Council of India. And once this ADR cell is being graded as an arbitration institution by the ACI, then all the disputes which is going to be administered or managed by this ADR cell would also be recognized, and there the persons with qualifications facilitated by the CA Institute would be considered as arbitrators. This is like a effective chain, and that chain is going to be now facilitated by the regulator. It is our duty to enrich our knowledge in arbitration by familiarizing with this act, Basic Arbitration Conciliation Act. Then we have to equip ourselves going into all these various judgments already delivered, or future is going to be delivered by the apex court of our country. And thirdly, you also have to get regular trainings, understanding the nuances of presiding as an arbitrator, participating in the arbitration as a representative of the parties, and also taking up of the role of an expert. These all we have to equip. Even if the age schedule has been removed, now it has been omitted, we need not worry. All these qualifications are going to be carried forward as a regulations by the Arbitration Council of India when in a year or a couple of years we are going to have that. At that point of time, we all are going to be acting as arbitrator. Here, one thing you have to be very particular. There are 4 major opportunities for all of us in arbitration. One is consultant. We can act as consultant in arbitrations. Second, we can act as arbitration counsel. That is a counsel representing the parties in the arbitration before the arbitrator. Third, we can also act as expert. And fourth is acting as arbitrator. 4 opportunities are there. 4 pillars are there. Consultant, counsel, then expert, and finally arbitrator. The third one, expert. In my limited experience in arbitration, I find most of the chartered accountants are taking up the role of experts to begin with. And if you can see, the major CA firms provide a service called forensic expert, or they call it the fraud analysis division of their practice. Here, the role of the firms is that they provide some experts, and those experts would obviously help the arbitrators as well as the parties representing before the arbitrators in bringing down the cost analysis in the dispute. The cost analysis is a very important thing which is not effectively dealt in the courts in any forums. When we are trying to take the cost analysis, it is all the way how we lawyers are presenting or the representatives are presenting. But in arbitration, the concept of the cost analysis is perfectly worked down, and there chartered accountants are having a great opportunity. We call it forensic experts, and expert is the best opportunity for chartered accountants to begin with. Secondly, the consultant. The consultant role is the another stage wherein down the line in our career, second year or third year, we'll get a lot of opportunity. Consultant's role is that if a client comes for any type of assignment or expectations or expertise what they are expecting with you, when you're going to draft a contract, predominantly the chartered accountants draft the partnership deeds, the basic agreements. Agreement to sale also is nowadays being drafted by chartered accountants, and it's good that many chartered accountants are even drafting commercial contracts. And perfect and well accepted with the arbitration. Sorry, the contracts have been drafted when we consider the commercial perspectives. All these commercial contracts do have arbitration clauses, and when we are looking into these arbitration clauses, and when we are going to effectively guide the parties in incorporating the arbitration clauses, then that is a great opportunity for you to be a consultant. Incorporating arbitration clause is a really great skill, and there we have two very interesting concepts called ad hoc arbitration and institutional arbitration. Ad hoc arbitration, what we can commonly see is that the arbitrator and the parties, they themselves structure the process from the appointment of an arbitrator till the completion of the arbitration process. It's all been managed by the arbitral tribunal or the arbitrators along with the parties. There is no third agency. The court has no role. There is no registry. There is no institution. There is no professional bodies to support this process. It's all entirely managed by the arbitrator as well as the disputing parties. This is ad hoc. The same arbitration, if it is being facilitated by an institution, a third agency, a body which is being authenticated by the parties, that becomes institutional arbitration. The institutional arbitration facilitates many aspects from the appointing stage till giving the award, or even post-award, maintaining the records of the arbitration proceedings. All will be taken care by the institution. They will appoint the arbitrators. If the parties couldn't agree, they will provide the secretarial assistance. They will also provide a good venue for conducting the arbitration, and they also maintain the records, the arbitration records. That's very important. Normally in ad hoc arbitration, we can't expect the institutions or the courts to maintain the records. It is a duty of the arbitrators to maintain the records. But there is no restriction of the times. There is no limitation. He has to keep on maintaining the records. And if it's quite busy, its records itself would obviously, like a docket explosion in the courts. That arbitrator also would end up in a huge docket explosion. That should not happen. That's why parties go to institutional arbitration. This ad hoc or institutional arbitrations is very important for us to begin with. We have to cautiously look into all these concepts, and when we are acting as a consultant and when we are drafting any commercial contracts, our great opportunity is to incorporate an effective arbitration clause. An arbitration clause is effective when that clause has 5 interesting components. One is the nature of the dispute. 2 is the number of arbitrators. 3 is the law, which has to be the procedural law to be adopted by the parties in that arbitration. 4th is the place of arbitration has to be prescribed. And 5th is the language of the arbitration proceedings. I'll just repeat: nature of the dispute, number of arbitrators, the procedural law or the arbitration rules which has to be adopted, the place of arbitration, and the 5th one is the language of the arbitration proceedings. If you are going to arbitrate, what disputes has to be arbitrated has to be clarified only by the clause. That is the nature. And if you have the nature, all disputes or certain disputes or only few disputes or any disputes, it's all left to the nature. Next, the number. The number has to be specified. If the number is not specified, the law says that it has to be only 1. And to appoint that 1, the 2 disputing parties have to agree. There is a remote possibility for the 2 disputing parties to agree for that arbitrator, and ultimately, if it is an ad hoc arbitration, they have to approach the courts, the High Court particularly for domestic arbitration and Supreme Court for international arbitration to get the arbitrators appointed. There is going to be a substantive delay when the courts have been approached to appoint the arbitrator. If it's an institution, default they can appoint within 7 or 10 working days. They can make the appointment quite easily. This number is very important. Specify the numbers. And there was an earlier practice of consultant like us, including all of you, to incorporate the names of the arbitrator. That also is quite a good practice, and it's an acceptable practice. You can also name the arbitrator. The only when a dispute comes, and at that point of time, if there is a conflict of interest with the parties or the disputes and the arbitrators, then that arbitrator could not be appointed. We have to find for alternative to that appointment. Otherwise, that also stands good. We can also name a specific person to be an arbitrator. But we have to be very clear. The second point is that number of arbitrators we have to clearly mention, 1 or 3. The law gives an opportunity only for odd numbers. That we have to cautiously recommend when we are suggesting an arbitration clause. Thirdly, we have to specify about the procedural law. And most interestingly, when you are dealing with cross-border contracts, international contracts, when you are dealing with the export-import contract, there will be just a purchase order. That purchase order will be drafted by us. And in that purchase order, we have to include the arbitration clause. In such an arbitration clause, it has to be international. We can agree for India to be the place, or we can also agree to the another country like China or Singapore, the Malaysia. All these places also can be considered. At that point of time, that particular country arbitration law has to be incorporated in that arbitration clause. When you're dealing with two different nationals, and in that contract, we have to obviously consider either one party's procedural law or a neutral country procedural law. That also is possible. And this is complemented along with place. The place, if it is not specified, then the procedural law has to be very clear, so that based on the procedural law, we can determine the place of arbitration. Assuming that in the arbitration clause, it's specified that the Arbitration Conciliation Act shall be applicable and the place is omitted, then when at the time of arbitration, the place has to be India, because the procedural law of arbitration of India would be affected only if the arbitration is conducted in India. Similarly, if it is in another country, that country arbitration law has to be adopted. Both ways it is complemented, the procedural law as well as the place of arbitration. Finally, the language. Language also is better to be placed. If all these 5 components are clearly incorporated in your arbitration clause, then at the point of time of invoking the dispute for arbitration, the parties can effectively conduct the process, and that process can be very successful. Otherwise, even to scrutinize whether this arbitration clause is valid or not, the parties have to go to the courts, and then the courts have to decide, and there will be obviously a delay and add-on cost. Avoid that. As a consultant, you have a great opportunity. There's a second opportunity next to expert for you to explore drafting arbitration clauses, and that too effective arbitration clauses. Thirdly, counsel. In arbitration, anyone can represent the parties, and in most of the arbitration, you can see that the parties themselves are acting as representative. They are not engaging any third person like lawyers or chartered accountants or company secretary, depending upon the technicality. They themselves are managing. But still, if it is quite a reasonable value dispute, they are engaging, and there is no compulsion for the parties to only engage a lawyer, only engage a chartered accountant, only engage a company secretary. Anyone can be engaged. Even a normal person with a normal graduate, or even a person who is just 18 plus age, he can also be a representative. The only thing is just an authorization letter is sufficient for the arbitrator to permit that representative to appear before that arbitral tribunal and conduct the case. Here there is no legality, too much of legality. There is no applicability of CPC and Indian Evidence Act. That means anyone can represent the parties. Obviously, we professionals can also represent the parties. Not only in India, in any part of the world wherein the model law is adopted. Even if the model law is not adopted, some institution, if it's an institutional arbitrations, Even in that country, the procedure law is not model law. That institution might permit, most of the recognized institutions might also permit the representative, any national, to appear in the arbitration process, conduct the arbitration, and get back to the country. There is no restriction. That we have to clearly understand in the arbitration process. Getting back to the qualification, what we happen to commence. So, okay. While looking into the 8th schedule, we were quite worried that now it has been omitted, but we need not worry. The basic principle is that there is no legal requirements to become an arbitrator. However, where disputes involving issues of law, having a law degree is usually most advantageous. That's all. But it doesn't confine you only to have a lawyer to be an arbitrator. And if the dispute involves issues of fact, then someone who is an expert in that particular sector, a domain expert, may be the most suitable arbitrator. One interesting thing is that arbitration institutions, most of the arbitration institutions offers pathway programs, which provides progressive educational training for a newcomer in the field through the advanced level. All the entire concept is also being guided. Even in your CA Institute, the certificate course initially was like a basic course. Now it has become considered to be an advanced course. Likewise, large range of courses have been included by various institutions. You can also try, not only from your institute, you can also do it outside various institutes. I do have some slides for you to share, and that if you try to take up, you will have lot of opportunity to participate in the arbitration process. What are the skills an arbitrator, a person who is going to act as an arbitrator, should possess? These are some basic out of my exposure in arbitration. An awareness of sensitive nature of disputes. We have to have a reasonable awareness. Problem solving skills with self-confidence in the decisions. That has to be very clear. Anyway, we are going to give a decision. That decision might be right or wrong. We have to be an effective person who can solve the problem. A commercial awareness as well as negotiating skill. As an arbitrator, we can also act as mediator and resolve the dispute amicably. There is a very clear provision. When you happen to look on the Arbitration Act, one provision, section 30, says about settlement. In arbitration also, settlement is possible. For that, the arbitrator should have a good negotiating skill. Further, interpersonal skills with the ability to work well with teams and other people. That is, as a teamwork, an arbitrator is not an individual. An arbitrator is a person who is going to manage the parties, the disputing parties, their representatives, the experts. All the parties are involved in that process. Anyway, it is confidential process. Nothing beyond these persons can be aware of this particular process. It is totally private and confidential. Only the arbitrator, the disputing parties, their representatives and experts are permitted to participate in the arbitration proceedings. But still, this team has to effectively work. And as an arbitrator, you have to have that interpersonal skill to manage this particular process. Further, communication skill, the language skill, and the presence of the humor also is very important when you are sitting as an arbitrator. Knowledge, experience of the relevant sectors, the areas of laws, particularly dealing with the cross-border transactions, as well as international arbitration codes also is quite a good qualities. And most interestingly, which has been borrowed from the 8th schedule norms. All these are, we can also see in the 8th schedule norms, the ability to be impartial, evaluation of evidence, and also making effective decisions. All these should be basic skills. These are just the basic skills of an arbitrator. But the law says very clearly that the arbitrator should be independent, impartial, unbiased, as well as neutral. If you have that qualities, independent, impartial, unbiased, as well as neutral, all these four qualities, if you possess, then you are the best arbitrator. You are the learned arbitrator. You are the best choice of the parties to sit as an arbitrator, unless and until it's appointed by the courts or by the institutions. Okay. Career prospects. When we come to the career prospects, the work experience also matters. It is always useful to gain some type of work experience to see what kind of arbitration you should like to work and to make useful career contacts. It's very simple that whenever you get an opportunity acting as consultant, acting as expert, acting as counsel in arbitration, or assisting some lead counsels or a senior counsel, this is all some work experience for you to go and sit as an arbitrator. For that, there are some organizations like Association for International Arbitration, International Chamber of Commerce, London Court of Arbitration. All these organizations gives a lot of opportunity. In India, some institutions are here. On the subsequent slides, you can look upon that. And if you are wishing to work in commercial as well as international arbitration, it's very important to know what's actually happening globally in the commercial as well as the political arena. This we had to seriously look into, and we have to arbitrate. Why? Because there was one very interesting example in Middle East, in the Emirates, United Arab Emirates. There was one international arbitration wherein an arbitration was presided by an Australian arbitrator by name Professor Doug Jones. He arbitrated, and ultimately he gave an award which was in favor of a national who was a Qatari national, and the losing party was entity of Emirates. But the arbitration happened in Dubai. The award was against the Dubai entity, and ultimately the Dubai entity challenged that award in the courts, and the court found that the arbitral tribunal was partial and biased, favoring the Qatari national. Unfortunately, there is a legislation in Emirates that if the court finds that arbitrator is partial or biased, then the arbitrator can be punished and penalized. Even imprisonment is possible. And even now, this particular arbitrator couldn't go to the jurisdiction and arbitrate because of this particular judgment. At any point of time, when he enters into that jurisdiction, he can be arrested. We have to think as an arbitrator, we have to cautiously look upon what's happening politically and what are the laws in the jurisdiction where you are going to arbitrate. It seems to be lucrative, or it also carries some responsibilities and liabilities. Cautiously do. But in India, an arbitrator is immunized. You need not worry. An arbitrator is immunized. And if you go to some jurisdiction like Sweden, they have a law which clearly mentions that the arbitrators are totally immunized and they are not liable for their act as well as omissions. So much of leverage is given, trust is levied on the arbitrator, and that arbitrator has to equip himself before being appointed in any case. That is the career prospect what we have when we look into arbitration. In India, why choosing India, that also matters. In India, now it is the judiciary is pro ADR. Not only arbitration, the courts are facilitating mediation, conciliation, as well as lok adalat. At this point of time, we have a good opportunity. We have a good opportunity to take up ADR as an effective practice. But one thing we have to be very clear here. taking arbitration, particularly arbitrator, it is not so easy. And at the time of appointment, three things, at least two things you have to keep in mind. The first, the remuneration. I think it is visible to all. I have taken a schedule from the Act. It is fourth schedule of the Arbitration Conciliation Act 1996, which was included in the year 2015. Just look into it. The basic fee structure which has been given up to 5 lakhs. The model fee, it is just given model fee. It is for an arbitrator. The fees is 48,000. And if you look on above 20 crores, it comes to an average of a minimum of 19 lakh 87,500 plus 0.5% of the claim amount over and above rupees 20 crores with the ceiling. There is an upper cap of rupees 30 lakhs. This is a model fee suggested by the Act in fourth schedule. There is no compulsion to follow this, but still there is a guideline for us to follow. Minimum of 45,000 to maximum of 30 lakhs is the fees for an arbitrator in an arbitration process. This is a recommendation given by the Act, but it is not only the mandatory fee. It differs from individuals' experience, expertise, and exposure in arbitration. But if you are a beginner, you can just adopt this basic principle and you can fix your fees. But at the time of prospective appointment, fees alone is not the criteria. Look into the other schedules. The problem starts here. Fifth schedule. Fifth schedule, there are some categories of relationship. The following grounds give rise to justifiable doubts as to the independence or impartiality of an arbitrator. The one is the arbitrator's relationship, the parties are counsel. The next one is the relationship of the arbitrator to the dispute. Third one, arbitrator's direct or indirect interest in the dispute. Fourth one, previous services for one of the parties or other involvement in the case. Fifth one is the relationship between an arbitrator and another arbitrator or counsel. Sixth one, relationship between arbitrator and party and others involved in the arbitration. Seventh one, other circumstance. There are some various headings and totally 34 categories of relationship has been highlighted. Here comes the problem. Becoming an arbitrator is easy. Anyone can be an arbitrator if you look on section 11. But there are 34 categories, I mean, listed out in fifth schedule, wherein certain relationship has to be declared by the prospective arbitrator. And more interestingly, when you're giving a declaration, we had to look into a template. This is a template given in sixth schedule. You have to give your name, your contact details, your prior experience, including experience with arbitration, the number of ongoing arbitrations, and circumstance disclosing any past or present relationship with or interest in any of the parties or in relation to subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to your independence or impartiality. We had to list out not only that, circumstances which are likely to affect your ability to devote sufficient time to arbitration, and in particular, your ability to finish the entire arbitration within 12 months. Name is simple. Contact details you can give. Prior experience, if it is 0 also, you can just give 0. The problem starts from fourth point. Number of ongoing arbitrations. We are going to give, assuming that 10, fine. You can ultimately devote reasonable time. If some arbitrators are quite busy, if they're putting 50, that itself might give an opportunity for the parties anxiety that, oh, the arbitrator couldn't complete the arbitration within 12 months. Because now, after 2015, the law has given some time frame, 12 months for domestic. We can further add 6 months, 18 months on that. So much of development in the law has happened. And because of the development, the number of ongoing arbitrations matters a lot. If you're quite busy arbitrator, then your prospect of appointment might be remote. If you are reasonable, if you can manage and devote time, if you're dedicating your entire time to be an arbitrator, once the Arbitration Council of India is going to come, we are going to have a career. We are going to declare ourselves as an arbitrator. Like now we are declaring that I am an advocate, I am a chartered accountant, I am a company secretary, I am a cost accountant. Likewise, we can also declare ourselves as arbitrator. And once we are going to declare as an arbitrator, we are going to dedicate entire time for arbitration. At that point of time, the number of ongoing arbitration doesn't matter. The very, very vulnerable issue is that the circumstance, what you're disclosing, the third line, whether financial, business, professional, or other kind, unimaginable. It is like sky is the limit. Any type of relationship, fortunately, we have been given the 34. And out of the 34, if you come within any perspective, any of these categories, we have to give the declaration. Not only that, when you're giving the declaration, sorry, if it comes within 1 to 19 categories, those 1 to 19 are all reproduced in 7th schedule. Look into this. Arbitrators' relationship with parties are counsel. The same first point continues and ends with 19. The arbitrator or a close family member of the arbitrator has a close relationship with the third party who may be liable to recourse on the part of the unsuccessful party in the dispute. If it is within that 7th schedule, we are giving a declaration with a template given in 6th schedule. While giving, we are looking into 5th schedule, all the 34 categories. And while we are disclosing, that disclosure, if it comes within first 19 of the 5th schedule, then it is all reflected in 7th schedule. That means when we are coming within that purview of 7th schedule, immediately we have to look into one provision, which is section 12.5, which has been amended. I'll just run through that particular provision. 12.5, carefully look into it. Notwithstanding any prior agreement to the contrary, any person whose relationship, that is the relationship, business, professional, or any other kind, with the parties or counsel or the subject matter of the dispute, falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. Very, very unfortunate situation. We are going to give a declaration. That declaration is based on explanation 1. You can look into it. The grounds stated in 5th schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to independence or impartiality of an arbitrator, and the disclosure shall be made by such person in the form specified in 6th schedule. Explanations are given. We are looking into 5th schedule. We are taking the 6th schedule template, and now we are giving a circumstance of the relationship what we have. And if it comes within 1 to 19 of 5th schedule, that is, which is reproduced in 7th schedule, then 12 subsection 5 applies. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as an arbitrator. Very unfortunate situation. Look, if you're looking into 7th schedule, you got that appointment, you are on the verge of being appointed as an arbitrator, you're going to give a declaration, and that declaration is coming within 7th schedule, then you have to immediately you have to reject that offer. Obviously, you have to relinquish that particular position. What is that relationship? you are going to give a declaration. If you are going to look into that 7th schedule, it is all quite reasonable. These 7th schedule is or the 5th schedule, both are being taken from a very interesting soft law. You have to, before venturing into arbitration, first you have to look into one interesting soft law, international soft law, which is called IBA guidelines. IBA, that is International Bar Association. IBA guidelines on conflict of interest. IBA guidelines on conflict of interest in international commercial arbitration. In that, they have given 3 colors. Like our traffic signal, given 3 colors. One is considered to be red, another is yellow, and the third one is green. If you are coming under the purview of green, then you are entitled to continue as an arbitrator. That means you are not coming within any of the 34 items or categories given in 5th schedule. When you are considered to be yellow, then you are coming within item that's categories 20 to 34 under 5th schedule. When you are coming within the category of red, then your declaration is within 1 to 19 of 5th schedule, that is simple 1 to 19 of 7th schedule. That makes you under section 12 subsection 5 of the amended act in 2015 clearly gives that that person is ineligible to act as an arbitrator. That means he is red, restricted. If the traffic signal is red, you can't move. The traffic signal is orange, you can either move or you can wait. If the traffic signal is green, you can freely move. The same thing applies for people going to act as an arbitrator. When you are going to take this great opportunity to sit as an arbitrator, you are cautioned with this. The caution is really a good caution, but you have to carefully look into that and put your declaration. Assuming that if you are not declaring, you are hiding, then if the parties comes to know, then that award is considered to be an award which is possessed out of fraud or undue influence. You should not give that scope for the one of the party post award to be taken for challenge. And if you look on these provisions, what has been given, the categories given in 7th schedule, I just read some interesting one, at least one. The arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the party. This was happening predominantly in most of the government departments. The large contracts, multi-crore arbitrations, you can see, like bodies like railways, military engineering services, public sector undertakings, like the Navaratna companies, like IOCL, BPCL. If you look on, as you are having a petrol outlet, you are entering into a franchisee contract. If a dispute arises between you and the franchisor, that is a petroleum company, in the arbitration clause, it would be mentioned, general manager of IOCL Chennai region would be an arbitrator. He comes under the category is an employee. An arbitrator is an employee, past or present business relationship with the party. One of the disputing party is Indian Oil. Other party is the franchisee. These two parties are disputing, and in the arbitration, the arbitrator is an employee of one of the party, IOCL. How can we expect that person who is a servant of one of the party, it's a master-servant relationship, to effectively act in an impartial, unbiased way and deliver the award? Straight away is ineligible. Not only employee, consultant, advisor, all these are possible. Another example, I'll just straight away go to 14. The arbitrator regularly advises the appointing party or an affiliate of the appointing party, and the arbitrator or his or her firm derives a significant financial income thereon. This is applicable for all of us, whether it's a chartered accountant or lawyer running a law firm. We advise many clients on a regular basis in an individual capacity as well as a partner of a law firm or a CA firm. When we are advising one of the party, and if that party is a party in that arbitration process, or if that party is the appointing authority in that arbitration process, and if you are taking such an appointment, then you are going to declare, and that declaration makes you ineligible. 15 also is very interesting for us. The arbitrator has given legal advice or provided an expert opinion on the dispute to a party or an affiliate or one of the parties. See these are all considered to be direct relationship with one of the parties. Either arbitrator's relationship with parties or counsel, or it's a relationship of the arbitrator to the dispute itself, or the arbitrator's direct or indirect interest in the dispute. Assuming that an arbitrator has purchased a share in a particular company and that company is involved in that arbitration, obviously it becomes a situation, a category which has a significant financial interest in the outcome of the dispute. Not only that, the arbitrator holding shares either directly or indirectly, that's the point there. If you look on category 17, the arbitrator holds shares either directly or indirectly in one of the parties or an affiliate of one of the parties that is privately held. That also makes that person ineligible to act as an arbitrator. Be cautious. Look into all these 19 points which has been given in 7th schedule. Beyond that, we need not worry. That is possibility of bias only. That you can you are not put in a position of ineligibility. You are still eligible with certain possibility of challenge by the parties. But that challenge also can be dealt by the arbitrator, not by the court or the institution. That arbitrator himself can decide on the challenge. But if you're coming within this 19 categories, you will be in a worse situation. There is high possibility of making you ineligible to act as an arbitrator. And for that, it is not only confined with you in the personal capacity. If you are dealing with the entity, that entity's affiliates also has to be considered, and it also considered a close family member also. If you look on point number 18, it says that a close family member of the arbitrator has a significant financial interest in the outcome of the dispute. We might have siblings, dependents, our parents, our children. All these persons are considered to be close family member. If you look on explanation 1, it says the term close family member refers to a spouse, a sibling, child, parent, even worse, or a life partner. All these are included as a close family member. If you look on explanation 2, the term affiliate encompasses all companies in one group of companies, including the parent company. We have a lot of group companies. When a small organization has a group, all the affiliates would be there. If not only you, if your close family members has a significant financial interest in the outcome of the dispute, whether a party or its affiliates, that also has to be declared. At time of declaration, if it comes within the first 19 of 5th schedule, then it is all ending up in 7th schedule, making you ineligible to act as an arbitrator. This is an indirect qualification which is being prescribed under the law in 2015 itself. It still stands good, which was a soft law in international practice. In India, we have adopted in the legislation itself as a mandatory provision. This mandatory provision has to be seriously looked upon when you are going to act as an arbitrator, not as a consultant, counsel, or an expert. But when you are going to change your career as an arbitrator, all your present and past relationship has to be seriously looked upon, verified, and a declaration or a disclosure in writing is mandatory looking into these schedules. The template is given, the categories are given, take it and give it. The only thing is that if you're coming within the 1 to 19, you are under yellow, you are under red list. If it is beyond 19 and till 34, you are under the yellow list. And if you are not in either of these categories, then you are under the green list. You can easily arbitrate. But all these has to be seriously looked upon when we are likely to be taking the arbitral assignment in India. That's why I just wanted to highlight when I took this slide, why India. Okay, there are multiple sectors. I just highlight some sectors straight away. In addition to construction sector, financial sector, we do have sectors like investment sector, securities market, that is capital markets, commodities, commodity market, intellectual property rights, domain name disputes, space arena, agriculture, sports. All these disputes can also be arbitrated. And interestingly, as chartered accountants, you all have a great opportunity dealing with securities market, that is capital markets. We have an in-house mandating system of arbitration happening in all the stock exchanges. Many would be already familiar, and you have a lot of opportunity to sit as arbitrator as well as represent parties in an arbitration. It is a closed door arbitration happening within the stock exchanges. The regional centers of the stock exchanges, whether it is BSE or NSE or MCX when it comes to commodities, or the other exchanges, metropolitan exchanges or various regional exchanges, they have their own in-house mechanism of arbitration. There you can arbitrate or represent the parties, the investors, or on behalf of the trading members, the stockbrokers, you can also defend the cases. That is the securities market or the commodities arbitration. All these are avenues wherein we can explore and sit as an arbitrator or a counsel or even an expert. Getting back to construction industry, the construction industry, if you look into the construction industry, it's very clear that it is the backbone. It is our clear backbone of Indian arbitration. The total amount of investment that is currently tied up in arbitration alone, is in 70,000 crores. All the major construction industry like naming few, L&T, Gammon, Afcons Infrastructure, Sapurji, Palanji, all these are big players, construction industry, and the small players are also there, small builders. All these people are ending up in huge construction disputes. There also financial experts are having opportunity to sit as an arbitrator also, along with technical persons. The construction industry in India accounts 8% of the GDP and the largest direct and indirect creator of employment. Huge employment opportunities given by construction industry. That means the dispute also, it is like cost follows the event. Here, the construction industry, to what extent it is contributing to the GDP, it also contributes to disputes. And if you see, more than 64% of the total claims raised against the government entities are still pending in arbitration. This one thing, it is very clear that this call for good and willing arbitrators who are ready to dedicate themselves to facilitate the idea of arbitration in this field. In construction industry also you have opportunity. Next, in maritime also you do have opportunity. For that, the maritime arbitration rules set out in India, at least the Indian Council of Arbitration, that is called the Maritime Arbitration Rules of Indian Council of Arbitration, has to be taken into consideration. And the scope of maritime arbitration, which covers, I think many people would be familiar with some maritime industry, but for better understanding, it covers the charter parties, the bill of lading, the carriage of goods by sea, the marine salvage, the towage of vessels. Now, I think many would be aware of this Swiss Canal blockade because of one ever taken that particular vessel were touched ashore on the Suez Canal. Because of that, the huge damage, and now the port authority, Swiss Canal Authority, is going to claim more than $1 billion from that particular carrier or the charter party. Likewise, huge opportunities there, and India being having a lot of coastal area, we do have a lot of opportunities to get involved in maritime arbitration. To add on, we also have some damage claims relating to pollution, groundings, fire, there's marine insurance, accidents of ships, whether in port or at sea, including damage to fix a floating object on the boat. Many opportunities there. Removal of wreck and marine pollution also comes within the scope of maritime law. This gives lot of avenues, but one thing, these type of disputes, maritime disputes, are quite considered to be specialized, and to be specialized, there are some interesting point we have to seriously keep into consideration before appointing. We have to be empaneled arbitrators in arbitration institutions like Indian Council of Arbitration. We have to provide guidance to we are responsible guidance to other arbitrators as well as parties. We have to be in a position to determine the scales of arbitrators' fees. The other registration fees and administrative charges of the institution should be, we have to be familiar, and how to publish an arbitral award. Here, why publishing an arbitral award is that in institutional arbitration, there is one very interesting development in all the major institutions. In India also, the trend has changed. There is a concept called scrutiny of an arbitral award. An arbitrator, once he's ready with the draft award, that is the decision or the judgment, it is not that he is immediately going to share with the parties, that is publishing to the parties. Before publication, that arbitrator or the tribunal has to submit to the institution, and the institution would look into the technical, not the core of the judgment. It is on the basic typo errors, grammatical errors, computation errors. All those have to be seriously looked upon by the institution, and the institution has the authority to ask the arbitral tribunal to make necessary basic errors, not the decision itself, the basic errors, so that it will be a foolproof document before being published or before being shared with the parties. So much of care has to be taken, and very interestingly, when it is maritime arbitration, the institutions have so much criteria before an arbitral process has been commenced, or even after commencement before writing the arbitral award. As I just mentioned earlier, various sectors are there dealing with arbitration, and when it comes to exploring the opportunity, there are some accreditation also. The most accredited arbitration training providers also hold some professional directory. If you see the CA Institute, particularly the Committee for Economic CECL, the committee has a maintain of the panel of arbitrators, or a list or a directory of arbitrators, where you can find the entire list of arbitrators with their profile, basic profiles. And we can also find opportunities from independent or specialized arbitration services, NGOs, IGOs, independent advisory centers, public sector undertaking, regulatory bodies, as well as trade unions. These are some places where you can easily get an opportunity to arbitrate and get involved into arbitration. To add on, we do have some professional bodies. ICAI is listed out here, but anyway, you can just include that. Bodies, professional bodies like the Kuwait Foundation, Conflict Resolution International, Advisory, Conciliation and Arbitration Service in UK, Chartered Institute of Arbitrators, UK, London Court of International Arbitration, UK, London Maritime Arbitrators Association, UK, International Chamber of Commerce in Paris, and various centers. And if you look on the picture, various arbitration institutions, which are all professionally like acting as a professional training bodies, in addition to acting as institution, they do also facilitate the arbitrators and their careers to become arbitrators. All these institutions, you can have a good networking, and we can also participate as panel arbitrators with establishing your profiles. You can first get the training from those organizations, then you can panel in those organizations along with ICAI. This is one small example I wanted to deal with cost. If you're going to take in an international perspective, when you're going to take arbitration exclusively, this is quite salary perspective or remuneration perspective. You can see this is for one case. This is not for your multiple cases. For one case, the starting level arbitrator in an average per hour $20 to the maximum of $38,000. Junior level, it is 22 and 46,000. Mid level 30 to 63,000. Senior level, it is $45 per hour to even $1 lakh per hour for one case. Imagine the opportunity, and particularly the monetary compensation what you are going to get when we are getting involved. This is just not a exact figure. It depends upon your experience and expertise. In India, we have the fourth schedule. That fourth schedule is a guiding basic principle. Based on that and with your expertise, it can just go on. It will be just an addition, not a lesser amount than the model fee which is being suggested in the fourth schedule. Some professional development also you have to look upon. You have to get some trainings with all these institutions like ICC, CIAB, ACAS. Then like continuing professional development, I think your institution also has, and this training, this session also is considered to be like a continuing professional development CPD. You also have some forums like young arbitrators forums, young if you're less than 40, these young forums are there. If you are 40 plus, there are other forums which is not for young practitioners but for senior practitioners. You can get involved so that your exposure, your updation in arbitration would best suited, and it can act as arbitration, not only in domestic arbitration, in international as well as various sectors. That professional development is very much required for us to reach the destination to sit in large domestic as well as international arbitration. To conclude, what I want to say is that arbitration is still a growing alternative to traditional litigation, and here this means there is going to be genuine opportunities for dispute resolution professionals, that too with experience and reasonable expertise in arbitration proceedings. This skill you have to develop. Empanel yourselves in arbitration institutions, contribute articles to various professional bodies in arbitration and mediation, do a lot of consultancy work, incorporation of arbitration clauses in all the commercial contracts, appear before arbitral tribunal subject to availability of the brief by clients in dealing with such disputes. Explore all these, you'll get the experience, you have that expertise, particularly in arbitration proceedings, then the genuine opportunity for dispute resolution professionals is available, because the shift is going on from litigation to arbitration. All important cases, constitutional issues, criminal issues, and disputes which cannot be arbitrated alone is being taken care by the courts. All other commercial disputes is all being taken to arbitration. In mediation, we have some more value additions to the disputes we taken. This is the greatest opportunity what we have. Once you establish yourself through these basic arbitration work and receive some professional accreditation, you will be in a position to apply for major senior roles. That is, you can arbitrate in big arbitration, like all of you would be very happy to arbitrate the disputes which recently happened, wherein the Kane Energy was successful against the government of India. It's a big arbitration. The earlier days we had the arbitration like the merger of the takeover of the airlines, the early airlines by Jet Airways, multiple airlines by Jet Airways. All these are major arbitration wherein we consider as a senior role. Our senior role of acting as an arbitrator is our ultimatum. This is the opportunity what we have. There are various opportunities, but ultimately we have reached there. This often involves taking on more high profile and complex cases where the consequence of not reaching an agreement could have major repercussions. And this has a significance in all types of arbitration. Whatever arbitration, construction or finance, or it's a securities market, or even an agriculture arbitration, we have a lot of opportunity. We have, whether it is high profile or complex, it is very common in all sectors. It's very, very remote possibility for the parties to reach to a amicable settlement. And finally, the final point, what as an arbitration practitioners to all of you, as an opportunity, if you want to grab an opportunity in arbitration, you have to be self-employed. You have to be self-employed, not as a lawyer, not as an advocate, not as a chartered accountant, but as an arbitration professional. Thank you. Thank you for this opportunity to present about this opportunity for professionals like us in arbitration.
Thank you very much, sir, for your lucid presentation. There are some questions. Can you take, sir?
Yes, sir. Sure.
I'll just post it up. 1 minute. 1 minute.
Shall I read it for you, or you will see on the screen?
Yeah, I could see. Okay. Mr. Sitaraman has asked, do the high courts recognize passing the certificate course conducted by ICAI as adequate qualification for appointment? If so, what is the procedure for empanelment? Mr. Sitaraman and others, as of now, no high courts have the concept of recognizing any courses. If the certificate course is recognized by any professional organization, that itself is sufficient. The only thing is that the high courts or the Supreme Court, they want to go to include in their panel these enlisted persons who have completed the certificate course. That itself is sufficient. But there is no mandatory concept of recognition as of now. In future, it might come. Second one, about qualification for an arbitrator. CA with 10 years of practice, what about CA with 25 years corporate experience wants to act as an arbitrator? Insolvency professionals and registered valuers have given clearly practice or corporate experience. Mr. Sai Baba and others, it is very clear. We need not worry about this. 8th schedule has gone. 8th schedule has been omitted in the 2021 amendment. If the regulations are going to come, it might follow. The chartered accountants, the practicing chartered accountants, 10 years is only given in item number 2. If you come below the points, the item number 7, 8, it clearly gives any professional with any graduation, whoever employed or self-employed, you can also sit as an arbitrator. There is no restriction. You need not worry about any of these years of experience or years of practice. As of now, it is not implemented, it is omitted. Next, in the agreement, there is a clause for arbitration and also contains provisions of civil code. Is it correct to have both clause? Nothing wrong in it. Arbitration clause prevails over the civil code jurisdiction clause. There is one specific provision, section 8 in the Arbitration Conciliation Act. It gives an authority to arbitrate for the parties, not to litigate in the courts. Is it necessary to go to the court for recovery once a claim is awarded? It is the concept of enforcement, sir. Execution and enforcement cannot be done by an arbitrator, cannot be done by an individual. It has to be done only by the courts. No doubt, whatever might be the dispute amount or the rights claimed by the parties, enforcement or execution has to be done only by the courts. as per the civil procedure code. Next question: what is the legal sanctity of arbitrator? How to get the opportunity as an arbitrator? Is it by personal contacts only on any source or agency to get arbitration work? How the arbitrators generally engaged for the arbitration work? Okay, so much of trade secrets in one question itself. Legal sanctity of an arbitrator. Once you are appointed based on the arbitration clause, you are the master. Your legal sanctity is derived from the Arbitration Conciliation Act 1996 if you are arbitrating in India. Second, how to get the opportunity as an arbitrator? Is it by personal contact only or source? Okay, personal contact, surely your rapport building is there, your networking is there. Any source or agency, I think CA Mr. Pannaraj would provide the answer. How the arbitrators generally engage for the arbitration work. It all depends on your expertise and how you are focusing professionally in this market. That is why I wanted all of you to start with your consultancy assignment, go with your expert assignment, then the consultancy, then the representative, and then only you can reach as an arbitrator. Next one, how are legal cost and arbitrators fees dealt with in arbitration? Is there a link between this to the fees and remuneration to that? Mr. Krishnaswamy, it's very clear the legal cost and arbitrators fees are two different aspects. We have a cost regime now. Section 31 capital A of the Arbitration Conciliation Act gives you the answer. No doubt, the legal cost is separate, arbitrators fees are separate. Arbitrators fees are fixed based on the experience and expertise of the arbitrator in addition to the fourth schedule. Next, is there anything that is binding on the parties that they should abide by arbitrators award? What happens if a party defaults and disobeys? An arbitration award is equivalent to a decree. It's like a judgment. And if one of the parties is not comfortable with that award, that party can obviously challenge or go for an appeal in the courts. In arbitration, we have a limited grounds for challenge, that too on procedural ground. That challenge or aspect is there, but still it is not on the merits of the arbitral award. Next question, I think company audit or auditor cannot be arbitrators. Mr. Pavan Gupta, you cannot arbitrate the dispute which is arising out of your own organization where you are acting as a company auditor. Subject to your company, your code of conduct or whatever regulations of the CA Institute, you can still arbitrate. I think in one of my deliberation, there was a senior practitioner, the Central Council member says that there is no restriction for you to arbitrate with certain exemptions being given. Okay. Can an arbitrator engage himself in mediation or use mediation as part of arbitration proceedings? Very well, he can do. Will the principle of independence be in part by arbitrator engaging himself in mediation? The only thing, Mr. Krishnaswamy, you have to, before changing your role in an arbitration from arbitration to mediation, get a written consent from both the parties. If the mediation is successful, fine, you can complete, you can record that settlement as an award or consent award or award on agreed terms. If the mediation fails, you can still continue as an arbitrator if you have got the consent in writing. Otherwise, there is high possibility of you sitting as an arbitrator to be biased. Next one, can you please throw light on exclusion under section 12.5? It is very clear, sir. Mr. Mohan, sir, it's very clear. 12.5, it is reference to 7th schedule. Once you give a declaration, and if you're coming on either of these relationship as a declaration, what you're giving, that is a 19 declaration, then you are being considered ineligible to take that assignment. This is not after taking that assignment. At the time of taking the assignment, you have to look into this, get the details from the parties, their names, just a brief about the dispute. Then you have to give a declaration. Then only you'll be considered to be an arbitrator. In that way, this exclusion is being exercised. Next one, it appears only practicing CS with 10 years of holding the COP is allowed to practice. Any other with industry experience, domestic and international, has any chance. Mr. Shantiraj Kini, now there is no restriction. Anyone can act as an arbitrator. 8th schedule is omitted. How to enforce the arbitral award by counsel representing party which has award in its favor. This enforcement is as per the Civil Procedure Code. We have to approach the enforcement court, or we call the execution court, where the unsuccessful party, the losing party, has the assets, whether it is movable assets or immobile assets. Mostly predominantly, the immobile assets has to be taken into consideration, and that jurisdiction, assuming that the losing party is in Madurai. Madurai is a southern pilgrimage city in South India. Then the successful party can take that award with the help of a counsel, a lawyer only, an advocate only has to be engaged. In the execution court, it has to be enforced.
Those are the questions, sir. Thank you.
Yeah, thank you.
Queries are closed, sir. Shall we close it, sir? Any remarks from your side, sir? Any?
One interesting thing is that the certificate course of ADR has to be taken by all chartered accountants. It is really it will be helpful to all of you, because it's not only giving an opportunity, it is exposing you. It is putting you in a different legal subject. You are going to study about arbitration, mediation, and conciliation in total. It is, I think, it is stretched into some 4 or 5 weekends. Several hours we had to work on that. Not only that, you have to do an examination, not like a CA inter or a final exam. It will be quite easy having a MCQ type examinations, which was I think earlier created by Mr. Bhupender Shah. Now I only gave the question bank that is being followed by all the regional councils, and all better take that course, get acquainted with that subject. That is very important. And not only that, you also get exposed to opportunity representing the parties. Many of you dealing with partnership, the only opportunity is partnership deal. All the partnership deals ends up in disputes, and try to take those disputes on your own. Don't get an advice or consultancy with a lawyer like us. You can take that. That is going to be a starting point. That might be a small start. That start would give you a lot of opportunity. And the best and the worst example is one of the great chartered accountant, Mr. Loda. He did a mediation and arbitration with the Birla family, and after that, you know what is history.
Thank you very much, sir. Last small clarification I need from your side. What is the percentage of domestic and small, as you rightly pointed out now, that partnership areas, and these are the areas where, because in metros, the well-settled practicing chartered accounts many may not be able to take out time for this at a later stage. After practicing for 5, 6 years, 8 years, they would be busy with the traditional practice and the legal litigations in that area. But in official areas, many capable people may be there, other than metros. There, what is the percentage now, as of now? You would guess for the opportunities of the total in domestic areas, domestic dispute.
Yeah, in domestic disputes, the major hub is the metropolitan cities. The major hub, the opportunity is there. And when it comes to official areas, the other 2-tier and the 3-tier cities, as well as other smaller cities or the taluk headquarters, the opportunity is abundant.
Okay.
There is whatever disputes I highlighted are all fancy names, like a securities market, investments are all fancy. All the disputes in the official area, taluk means starting from a small family arrangement. The chartered accountants are preparing the family arrangement, and they are running the legal show of all the family concerns.
Yes.
It is individual, the concern, all can be managed, and the percentages, when it comes to the value of the disputes, the metropolitans are high. The quantity wise, 90% are dealt by Mofussil and Mofussil lawyers.
Okay. Excellent.
That-
Thank you, sir. I would take a clue from the. We all will take a cue from your this one. Most of our members would not have thought on these lines. See, if it is arbitration, it is a different field altogether. That will be the impression. Number one. Number two, it is only at a higher level, like corporate level and big level. When you took the name of partnership firms, it immediately stuck to me. In my experience of 34 years completed, 35th year practice, sir, I have seen the success rate in partnership is not more than 10% if it is a real partnership, unless it is a family partnership that is successful. Real partnership successful is only, in my opinion, in smaller areas, it is not more than 10%. Definitely, there are disputes everywhere, and if they themselves get resolved or they go to court or something like that, there the role of members is there. A good beginning can be done from that point, as you rightly advised. So, thank you very much for this advice, sir. And we will conclude the program if there are no queries. And I'll take the pleasure of thanking you, sir. A great insight into the new area of professional opportunity. This is the thing which we have been discussing about in our council meetings with the chairman, because the newer opportunities are the only way out for chartered accountants in the future, because most of the compliance areas are being automized and they will be taken over, like bank audits, this GST things, income tax thing. Most of these things will be taken over by the computer systems due to automation, and also this faceless assessment. So litigation area is one area where we have to move on, and this is another area of what's called the legal practice where you have thrown light upon, and many feel that there is very less opportunity in domestic the disputes, but you have highlighted. We will try to call you once again, sir, to specifically, if at all we collect the information from our members, what are the types of disputes and how that those can be dealt with smaller areas of this one. By seeing the international arbitrator as your designation itself, most of us would not be what's called very free to ask the queries, but still there are so many queries. There would be many professionals at smaller areas who would be entering in this area. You have given a great idea and a great insight into this, and your presentation was so simple. I could not just get up from my chair, sir. Throughout your presentation, with rapt attention, I noted so many things. Even though we write that clause, arbitration clause is there in partnership deed, we did not know. We knew that the arbitration has to go to court if it is not binding, but we did not know, most of us, that the arbitrator's decision has a legal binding also. There is legal sanctity for that. So without that, many would have been using those things. So these are the insights you have given. Excellent presentation, sir. Thank you very much for your time.
Thank you.
And being a professional as an advocate, you are supporting the cause of the chartered accountancy profession. People like you are the real support for the expansion of our professional opportunities. Thank you very much for your time, sir. Once again, happy all the festivals name. I would call it Yugadi in Karnataka. I am sitting in Bellary, Karnataka. All other festival names also I would thank you for the sacrifice, and I wish all the best for your family. We have allowed you to be so kind enough to sacrifice the times for the SIRC. So SIRC is indebted to you for your time. I also take this opportunity to thank our colleague Revati Raghunathan madam, who came here and gave the introduction part of it, and also the delegates. Most importantly, this being the festival day, there are around 200 delegates who have participated this, and this technology has become so handy for all of us. By sitting at your place and their respective places, we are able to enrich ourselves. So thanks to pandemic, that the technology has become more perfect now during these times, and those people who are not at all using the technology also have become experts in this. So thank you all the delegates on behalf of SIRC. your participation is the real what's called energy or inspiration for us to conduct such innovative programs for widening the practice areas. I thank the back office of the SIRC for support, and also especially Mr. Selva for the technical support. No HS were there. Always he has been the real backbone of this technology support. So thank you, Mr. Selva, and thank you all once again. Festivities, greetings to all of you. Thank you once again, sir, in the Inbavijayan.
Thank you.
Thank you very much, sir.